Good afternoon. I'm Cindy Robinson, the Executive Director of the Illinois Library Association. Thank you for being with us today. We are fortunate to have Rebecca Glenberg, the Chief First Amendment litigator at the ACLU of Illinois and was previously the legal director at the ACLU of Virginia. For more than 25 years, she has worked to promote and defend the right to free speech, religious liberty, voting rights, privacy rights, immigrants' rights, LGBTQ plus rights, and other civil rights and civil liberties. Rebecca received her JD in 1997 from the University of Chicago Law School, where she represented clients in the school's homeless assistance program. I will turn it over to you, Rebecca.
Hi, everyone. I'm so pleased to be here, and I want to tell you that the ACLU and I personally so appreciate librarians and library professionals and everything that you do to protect the First Amendment. We just think you're great, and I am so glad that you are interested in learning about what you should be doing when immigration enforcement agents show up at the library. If you'll just give me a second, I'm going to share my screen. Okay. We're going to talk today about immigration enforcement, some legal stuff and some practical stuff. First, the disclaimer. This is a general presentation about the law, but it is not legal advice. All situations are different. So obviously you want to speak to an attorney about a specific situation. This is just a general knowledge presentation. Today, we're going to talk about making a plan. We're just going to go over that really quickly at the beginning, what some of the elements of a plan might be, and then we're going to go into more detail at the end after you've gotten the information in between about what happens when ICE enters the library, tries to inspect library records, asks questions, makes arrests, and the role of state and local law enforcement. And then with that information, the making a plan part should make a little more sense. So these are elements that I will suggest including in a plan. You should think about your own library and its operation and whether there are additional things that you should be planning for once you have a little more information about what may happen and what you need to be prepared for. Certainly a call protocol. Who are the people you need to get in touch with right away? Their contact information. Who within your chain has consent to allow ICE or law enforcement to search private areas of the library? Who's authorized to speak with ICE when they're there? What are the public areas versus the private areas of your library? Just outlined there in writing. Some instructions and basic information about checking the documents that ICE may present and figuring out what exactly is authorized by those documents. Some instructions about what if they want to see your I-9s or the employment eligibility verification forms. That's a little different from everything else we're talking about today. Instructions on how to document what happens, including a checklist. So first, getting to the substantive stuff, let's talk about when ICE enters the library. inspects records or asks questions. And this is mostly governed by the Fourth Amendment. You're probably familiar, but I'll just read it quickly. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So the Fourth Amendment places limits on when law enforcement can enter or search private property, seize property, or make an arrest. And it's stronger in those areas where there's a reasonable expectation of privacy, and it's weakest in public places. And we'll be talking about the difference between private and public in just a moment. First, I want to show you some examples of warrants. It's important to be able to distinguish between two types of warrants in the immigration context. So a judicial warrant is a warrant that is signed by a judge. You'll see the name of the court, such as the U.S. District Court for the Northern District of Illinois, and you will see a signature at the bottom, and it'll say judge. A non-judicial warrant or an administrative warrant, or also called a warrant of removal or warrant of removal / deportation, or a warrant for arrest. All of these are forms that are issued by a federal agency, by ICE or by the Department of Homeland Security. They're signed by an agency official. You will see at the bottom again a signature that does not say judge. It will say authorized official or something similar. So here, and I don't expect you to be able to read this in detail, but what is important about this sample I-205, which is an administrative warrant, it's issued by the Department of Homeland Security. And it is a warrant of removal or deportation. By this heading and by the signatures at the bottom, which are signature and title of immigration officer. Oops, got ahead of myself. You know that this is an administrative or ICE warrant. It's not a judicial warrant. And this is a similar, just another warrant form from the Department of Homeland Security, but this is a warrant for arrest of an alien as opposed to deportation. Again, it says U.S. Department of Homeland Security, and the signature is the signature of an authorized immigration officer. And this is a judicial warrant. So a judicial warrant will have the name of the court at the top. It'll have a judge's signature at the bottom. Now, it may not be this exact form, but what you're looking for is a court at the top and a judge at the bottom. So what's the difference between these? When ICE enters the library, they can enter the library or areas within the library that are open to the general public without a warrant. So if your library is closed to the general public, for example, if you are a university library and only people with student IDs or faculty IDs can enter, then that is not a public area, right? We'll get into that in a minute, but you do not, but the areas that are public, as in, most areas in a public library, can be entered without a warrant. But private areas, the law enforcement official will need a judicial warrant. So not one of those administrative forms, but the judicial warrant with the court at the top and the judge at the bottom, or consent from someone with apparent authority. So consent, I'm going to highlight every time we see that word, because once there's consent for ICE to do something, then any Fourth Amendment limitations go away, right? You've consented. You can't argue later that they violated the Fourth Amendment. And note that it says someone with apparent authority. That's because the law enforcement officers don't necessarily know and can't tell just by looking at you who has the authority to consent. So that's why later we're going to want to make clear who does have that authority, and only those with authority that only those with authority actually consent. Okay, so these public or private spaces, and I'm thinking mostly of public libraries here, but this applies wherever. A public area is anywhere an officer could enter if they were a member of the public. So, for example, in a public library, we're talking about the stacks, we're talking about public restrooms. If you happen to be a library with an adult-only area, because the law enforcement officials are adults, they get to enter that area. It's a public area insofar as if this officer were a member of the public, they could enter that area. And a private area is where members of the public cannot enter, or this ICE officer in particular could not enter if they were just a member of the public. So maybe it's a employee lunchroom. Maybe there's a checkout area that's sort of enclosed by a circular desk, where you don't allow the general public to be. Maybe within your public areas, there are locked filing cabinets, and those would also be private areas. And then there are some areas that may be open at times and closed at times, or open to specific people and closed to others at specific times. So for example, if you have meeting rooms at your library, maybe it's locked when it's not in use. In that case, it's during those times, it is private. Maybe it's open open to the public when it is in use, or maybe it's open only to people who have registered for the event, or maybe it's open only to people who have a library card. And so all of those limitations apply to the ICE officer. He's like a member of the public. And so if the ICE officer doesn't have a library card and you need a library card to enter this area when there's an event going on, then ICE cannot enter without a warrant. It's a private space for those purposes, right? So sort of to summarize, ICE may not search the private areas of a premises or seize the property of a library without a judicial warrant, court name on top, judge name on bottom, describing the particular places to be searched, or items to be seized, or if they have consent. Consent is like a green light, saying, go on, come on in, you're welcome. Now, if ICE does any of these things without your consent, like going into a private area, you can say, I don't consent to your going there, or to your looking at that record, or to your taking that item, just to be perfectly clear about it, so they can't claim later that you did consent, or that by your silence you implicitly consented. Now, what if they want to look at records? ICE cannot inspect or seize a library's records without a warrant describing the records, which generally allows them to look at them or seize them immediately. A subpoena, which looks sort of like a court order in that it has the name of the court on top, but it may have someone else signing it other than a judge. But a subpoena requires production of records at a certain time and place. And it's something that is subject to court challenge before you actually produce the records. A court order is similar, but it may have additional conditions. It's also subject to court challenge or appeal before you produce the documents, unless it actually says you have to produce them immediately, but you want to read that court order carefully and see exactly what it says. And then there are the I-9s, the employment verification forms. And generally what they need to look at those, this is different from any other kind of record. So these are the records that you have for every employee that says, that confirms that they're authorized to work and states what documents you've looked at to confirm that. So in general, they can do what's called an I-9 audit, and they need to provide a notice of inspection and allow at least 3 days to comply with that. But again, as to any of these, consent overrules everything. If you consent, they can do whatever it is you consent to. If ICE asks questions of you or of anyone else in the library, you and they have the right to remain silent. It's a good right to remember and exercise. And under the First Amendment, you and others have the right to document what's going on, as long as you're not interfering or getting in the officer's way. You can photograph, video, write stuff down. These are all activities that are protected by the First Amendment. Now, in order to arrest someone for being unlawfully present, they need to have either a warrant, and this can be a judicial warrant or an administrative warrant. But they need some sort of a warrant, or according to the Immigration and Naturalization Act, they can arrest someone when they have reason to believe that the person is in the United States in violation of the law and is likely to escape before a warrant can be obtained for his arrest. And ICE has a tendency to forget the second part. Like, it's not enough that you think the person is unlawfully present. The person also has to be likely to escape before you can get a warrant. And I just wanted to quickly mention, we and the National Immigrant Justice Center had a lawsuit on this that was filed in the first Trump administration, that, among other things, requires them to, make sure that they have probable cause for both the unlawful presence and for likelihood to flee, and requires them to document those things. And it's in effect until May 2025. And the reason I mentioned this is that if you happen to see what you think is a violation of that, we want to hear about it. And there's a link on our partner NIJC's website that allows for reporting of incidents like that. I think it's going to be very unusual for anyone to be arrested for an immigration violation in a library, but this is what we really want to know, so that we can enforce this settlement for the remaining months that it's in effect. And then I'm sure you're all familiar with the library confidentiality law that makes all circulation and registration records confidential. and that these are not to be disclosed unless there's a court order or it's an emergency. And basically this situation is the narrow one where a law enforcement officer says, we have someone who just hurt someone very badly and they're going to do it to someone else unless we get to them within the next few minutes. And so we need their library records to get their address or whatever it is. Interestingly, that is a situation where you may provide those records to a law enforcement officer, but you are not actually required to. In any case, if that applies equally to a federal officer, like an immigration officer without a warrant. Again, if they don't have a warrant, they're sort of in the same place as a regular person. So under the statute, they need a court order. But they may also have a warrant or a subpoena or those other documents, and you need to comply with those as well, because the state confidentiality law isn't going to supersede the federal authority because of the supremacy clause of the Constitution. So that's sort of how that applies in that situation. So what we've been talking about is ICE or federal immigration officials coming to the library. And briefly, the role of state and local law enforcement in immigration matters is none in the state of Illinois. You should not see state or local law enforcement coming to the library to enforce immigration law. And that is because of a state statute known as the Illinois Trust Act, which forbids state and local police from enforcing federal immigration law. And that includes asking about someone's citizenship or immigration status, or stopping them or detaining them only because of their immigration status, providing housing for ICE. It's not really relevant here, or assisting ICE with enforcement operations. And the only circumstance under which they can do any of these things is if there's a federal criminal warrant, like the one we saw for the person's arrest. So if you do see state or local police or sheriff's deputies that seem to be trying to enforce immigration law, that's a violation of state law, and this can be reported to the Attorney General at this phone number and at this email address. Okay, so that is sort of the substantive information. And so how does that inform you in planning for a potential visit from ICE? So first, again, is your contact information. Who's the first person you call? Who's the second? Who's the third? Who are you going to call? Who has the authority to consent to a search? Who has the authority to talk to ICE on behalf of the library? And provide that make sure you just have in all one place all of that contact information and all of that information about these particular individuals. If you have an attorney, either in-house or on retainer, that is your first call. If you don't have an attorney, there is an organization called the Illinois Coalition for Immigrant and Refugee Rights, or ICER, that has a hotline. They are, the hotline is for immigrants, but they should be able to connect you with a lawyer who can advise you about ICE's presence in the library. You can see that among the things this hotline is for is to report ICE activity or to connect with an immigration attorney. So first is all of your contact information and what the role is of each of these people and what authority does each of these people have. Another thing that should be in your plan is a list of what are the public areas, what are the private areas, what are the areas that it depends on the circumstance or the person or the time of day, or any other factors that may influence whether a particular area is public or private at one time or another. Most areas will be straightforwardly public all the time or private all the time. And it's a good idea to put signs, you probably already have signs on your private areas, but putting law enforcement on notice that they can't just walk in there without a warrant. And then you also want some basic information about what the various documents are and what authority those documents give ICE. If they don't have any documents, they may not, without consent, and again, consent allows them to do anything, ICE may not enter private areas, inspect documents, or seize records or things without a warrant. If they have one of those ICE administrative warrants, they can arrest individuals who are named in those warrants, but they cannot, without consent, enter private areas, inspect documents, or seize records or things. That administrative warrant is only good for arresting or deporting a person who is named in the warrant. It doesn't get them anything else. A judicial warrant, on the other hand, court on the top, judge's name on the bottom, allows ICE to enter and search private places that are designated in the warrant. So if the warrant says that it can search your employee lunchroom, then they can search the employee lunchroom. Inspect or seize records and other items designated in the warrant, or arrest a person who's named in the warrant. If they have a subpoena, which often will look a lot like a judicial warrant, but it'll say subpoena on the top, ICE may demand specified items or records at the time and place stated on the subpoena. It typically will not allow them to seize items on the spot. And of course, it doesn't allow them to do all the other things about, entering private areas and searching and so forth. A court order, again, a court order will look a lot like a judicial warrant in that it'll have the name of the court on the top and the judge's signature on the bottom. And you just need to read that and make sure you understand what the order requires you to do and what it does not, and when you are required to do those things. Again, you may find that a court order gives you some time to comply, as opposed to a warrant that allows them to seize something right away. And a notice of inspection is what you get for those I-9 audits of employee records. And so you get that, it allows them to see the records at on a specified date that's going to be at least 3 days out. And lastly, you want a plan for documenting things. And you may even make like a form or a checklist or something to make sure you get some of this basic data down. Oops, sorry. Such as the date and time that the officers arrived and departed, which agencies were involved. Was it ICE, or was it maybe a different federal agency like the FBI or the US Marshals? Was it a state or local person, which it shouldn't be, like the sheriff? The names and badge numbers of officers. And these are things you can just walk up to them and ask for. They should give them to you. Sometimes they don't. What kind of documents were presented? Like warrants or subpoenas or court orders. Who is present and can be a witness? Sorry, I keep doing that. Playing with my mouse here. And who are the contact people that you called? What items, if any, were seized? And who, if anyone, was arrested? You may not know the person's name, but you can describe what they look like, about what their age is, that sort of thing, if someone is arrested while you are there. And then you probably also want to provide some narrative that goes beyond those basic data, like, who said what, to whom, and where and when, and where did they go, what did they do, for how long, what happened next, and after that, just all of the information that you may need, if something comes up later for you, but also if you are called to be a witness on perhaps in someone's immigration proceeding, or when someone is challenging an arrest. And there are lots of resources out there if you need more information. The ACLU has a series of videos about responding to ICE in different situations. They don't have a library one, but they have one. I think that's for businesses or employers. It's going to be very similar. I mentioned ICER, the Illinois Coalition of Immigrant and Refugee Rights, which has this hotline that you can call for help with issues involving immigration enforcement. And also their webpage has a bunch of resources, including lists of immigration attorneys, additional Know Your Rights materials, just a lot of helpful things on this resources page of their website. The American Immigration Lawyers Association is again helpful for referrals to immigration attorneys. The National Immigration Law Center, or NILC, has Know Your Rights guides, and in particular, helpful for you is likely to be the guide on warrants and subpoenas, and they have a little more detail than we got into today. And employers, which will cover the I-9 issues and other issues for employers dealing with ICE. And as Cindy mentioned at the beginning, the ALA has a guide at the Office of Intellectual Freedom has a guide called Libraries and Immigration Enforcement that is a very helpful read. And if all that fails, you can email me. I should tell you, I am not an immigration attorney. I'm someone who knows about constitutional rights like the Fourth Amendment and the First Amendment. If you need guidance on, for example, someone's immigration situation, like do they have a claim for asylum, or they're in detention and what do we do now? That's not going to be me. But if you have questions about your rights because ICE was there or is there, there's my email address, and there's our website. So that went really fast. I hope I wasn't talking too fast, but I am happy to take questions at this point.
Thank you,
yes.
Rebecca, first and foremost, for all of that wonderful information and taking time out of your schedule today to help us out. A lot of questions, so I'm just going to go through them. Let's see. There has been a lot of questions about the restroom. Is there an expectation of privacy in the restroom?
Yeah, well, so it depends on the kind of privacy you're talking about. But in terms of designating private and public areas of a library, it's all about who's allowed in there. So you may have some restrooms that are only for employees or for card holders, and others that are public. If it is a public restroom, then for purposes of these warrants, it's a public place. Now, someone's in a stall with the door to the stall locked. Well, that's an interesting question, isn't it? And I think, you know, probably that ICE officer is entitled to search, but if they're a decent human being, which they may or may not be, they will allow that person to finish with what they are doing. But that reminds me of another thing that I wanted to mention before we get more questions. And this may be one of the questions. You should not try to use those private areas that are inaccessible without a warrant to hide people who ICE may be looking for, or suggest to people who are concerned about ICE, well, if they come, you can always go into our employee lunchroom, which they need a warrant to enter. Do not do that, because there are criminal laws against harboring and transporting and hiding, basically, people who are wanted by ICE from them. So you have these private areas, a warrant is required, but don't try to take advantage of those to prevent ICE from doing what it's got to do. Okay.
Thank you for that. Here's a question. If there is a visit for a record inspection, would we be better off bringing those documents out to a study room, for example, instead of consenting to bring the officers into a private office area?
Yeah, so if you do bring them into a private office area, they can't like search minutely, but anything that's in their plain view are things that they can look at. So that's a very good question and a very good idea. The where you want this inspection to take place is somewhere where you're not worried about anything else that they may see, where you don't keep things like circulation records. And I don't know, not everyone may have an area like that in their library, but yeah, it's, use your discretion.
Would background check documents for library volunteers, which may have identifying information, be subject to the Illinois Library confidentiality law, or would we be required to turn that information over?
So the answer is whether or not, if we're talking about federal immigration authorities, whether or not they're contained within that statute, you're not going to need to hand them over without a court order or a subpoena or a warrant, a judicial warrant, not an immigration warrant. But let's just go look at the language of that law again. registration and circulation records. So your records about volunteers are not protected by this law, but they are protected by the Fourth Amendment, and all of those rules about warrants and consent apply.
Here's another question along the same lines. For libraries that are passport acceptance agencies, would ICE have the right to review patron applications that were yet to be packaged for mailing? We keep them in a locked drawer, however, open it each time we get an application throughout the day.
Yeah, the fact that you're opening a drawer to put things in or take them out doesn't make it less private. If it's a locked drawer that you don't allow anyone else into, then it's a private area and the warrant requirement applies.
Here's a question. Let's say our plan is to contact our library's attorney first if ICE comes with a judicial warrant. If we're trying to reach our attorney director, can ICE enter space, seize records before we've had the chance to speak with the attorney or director?
That's a great question. And the answer is yes, but you can also ask them, hey, we're trying to get our lawyer on the phone. Can you hold off? And again, sometimes they will respect your request and behave reasonably and sometimes they won't, but it's always good to ask.
If ICE agents raid, can we record any conversation we have with agents, whether it's video or audio, for records purposes?
Yes, so that will again, that will, as long as you're not interfering with what they're doing, that will be part of your First Amendment rights. Now, as to audio recording, there is the Illinois Eavesdropping Act, but that does not apply to the recording of officers doing their law enforcement responsibilities. So you may be prohibited from recording an officer who's engaged in a private conversation in a private space, but when they are in your space, you can record them doing their duty. And as a safeguard, it's always best to not do that secretly, because the statute only prohibits secret recordings. But yes, you can audio and video, and those are activities protected by the First Amendment.
Many Illinois libraries have their systems linked through SWAN with a specifically worded warrant order. Could ICE access all partnered library records through a single library?
Computer records, including records on a database site, are like physical records in the library. So in order to access any of those things, they need a warrant that says, and it should say the specific records that they're looking for, and or with specific names attached, some reasonably limiting what they're looking at. So the fact that they have a warrant generally doesn't mean they have free reign to go through the network and look at everyone else's records unless that's what's in the warrant. Yeah, so it's another good reason to be reading that warrant carefully, and don't let them in if they don't have a warrant.
If an ICE official gets consent to see something on one visit, is that consent still valid on subsequent visits? Is it transferable to another ICE official?
No, it's only for on the spot. Now sometimes, because we do things non-verbally, it's not clear exactly what the scope of our consent is, but it's not gonna last over any period of time beyond that specific incident.
And then just to piggyback on that question, if a frontline staff member gives consent, but let's say a director or a manager comes along 5 minutes later and tells them that they do not have consent, is it too late?
So what that manager needs to say, first of all, obviously, along with having a plan, you want to make sure everyone knows the plan and everyone knows who is or is not authorized to consent. And that frontline person can say, I'm not authorized to consent. But if they make a mistake, and if it appears to the ICE officer that the person has authority to consent, then the manager comes in. You can't do anything about anything they've already seen, or probably anything they've already seized, but you can cut them short by saying, this person did not have authority to consent. I'm the only one who can consent, and I don't consent. So get out of there now, please.
Let me see, what's another question? If you were observing an ICE arrest, could you ask the ICE agents what their probable cause is that someone is likely to escape, or would that be considered obstruction?
I would say yes to both. Because officers are can be, I shouldn't say anything about all officers, but officers can be temperamental. If you're distracting them, they may view it as obstruction or something. For purposes of that settlement, and probable cause, I would say if you see someone being arrested without a warrant and the person who's being arrested hasn't said anything about their ties to the community, for example, or their family or lack thereof in the area, that sort of thing, we're interested in hearing about it, regardless of whether you're able to affirmatively ask what the probable cause is. And my sort of practical advice would be, don't.
Here's a question. I'm concerned about the current administration / departments completely disregarding established rule of law. What happens if ICE disregards established laws and attempts to, say, gain access to non-public areas without a warrant or consent?
Yeah, so if they're violating the law, I would say, don't put your body in the way of them doing that. Document everything carefully. Video if you can. On the video, say, I haven't been shown a warrant. I've told them that this is a private area. All of that stuff. And the best that you can do is to try to challenge it later in court. They're the guys with the authority and the guns and so forth. And so you want to say as clearly as possible, I don't consent, where's your warrant? But I don't try to physically obstruct them, because you may be hurt and you may be legally on the hook, regardless of whether they are behaving lawfully or not. Get the evidence, get the witnesses, etc.
Can library staff keep a copy or make a copy of any document law officials show us for our records?
So you should receive a copy of a warrant. If you don't, and definitely you should receive the original of a subpoena. You should receive a copy of a court order, especially these things where you have to comply later. If you don't, ask them if you can copy it. But if they don't let you, again, it's sort of like, what are you going to do? So read it as carefully as possible. If they won't let you copy it, perhaps while you're reading it, you can take a picture of it. but you know, again, there's what they should do and there's what they will do. And they don't have a, you know, a legal obligation to hand it to you while you go to the copy machine.
Does a judicial warrant have to be signed from a judge from your library's jurisdiction?
Oh, that's a complicated question. So I think the practical advice is whether it is or not, if it's from a court and it's signed by a judge, you should comply with the warrant and challenge it later. The jurisdiction that, you know, it really should be from your jurisdiction. But there are sort of complicated issues always with when they may have jurisdiction to go outside their normal area. But again, I think the smart thing to do is comply and ask questions later.
There's a question. I have a staff member who wants to have red cards readily available out on our resource table. What are your recommendations on having those cards without any supporting information?
So are red cards, are you talking about like know your rights card? What is a red card?
Let me see. It looks like it's just a resource that the library is providing to people to know their rights regardless of their immigration status. Let them know they have certain protections and rights under the US Constitution.
Yeah, I mean, if you have confidence that what is in there is accurate, then I think it's fine to have that stuff out. You may want to make sure there's a number on it or an email or somewhere they can contact if they need more information or if they have questions. You may want to have a disclaimer either on the card or on a sign nearby that says this is not legal advice, like I did at the beginning of this presentation. But in general, we encourage you know, the distribution of accurate, trustworthy, know your rights information. Obviously couched in terms where people understand that it is general information and not, you know, it's not specialized to their particular situation.
Can ICE with a warrant arrest someone not named on the warrant?
No. Unless there is, unless, you know, unless they have probable cause or, you know, probable cause to believe that they are present unlawfully and are likely to flee before they can get a warrant, you know, the same, but just because you have a warrant for one person does not automatically allow you to arrest someone else.
What happens if an ICE agent threatens you? What should you do?
Well, first you should do what you think will keep you safe in that situation. If you are being threatened, like if you don't open that door, I'm going to punch you in the face. I would suggest opening the door and making it clear again out loud and documenting it immediately as soon as you're able to. I do not consent. I'm doing this under duress, etc. You know, to the extent you can make a video, great. Otherwise, write it down as soon as you can. And that is fodder for a lawsuit. It's fodder for challenging the admissibility in evidence of anything that they may seize, and so forth. I mean, if you're in a situation where you're being threatened, what can you do? I mean, if the threat is real and immediate, first protect yourself. and don't protect yourself by fighting back.
Are ICE officials allowed to bring weapons into the library?
So, I don't want to give a really confident answer to that question because I haven't really thought about it. My my intuition is that if their normal law enforcement duties involve carrying a weapon, and if they are allowed to be in the library in that it's a public space or they have a warrant, then they are allowed to carry the weapon in the library. But again, I said that with a question mark at the end. I'm not completely confident in that. But again, generally, federal law and federal authority will supersede state law that prevents them from bringing weapons into a library.
If a library program room is being used for a program that requires patrons to register in advance, is that program room considered a public or private area for ICE officials?
So that's private unless the ICE officials are themselves registered. So it's private temporarily, right? Because as soon as that meeting ends, if it's a room that you just allow people to go into and it's not being used, then it's public. If after the program ends, you routinely lock the door and don't allow people in, then you do that and say this is a private space other than people attending approved meetings or sessions.
Are you legally required to provide your name? Oh, are they legally required to provide their name and badge number, ICE agents, or anyone coming in?
Yes, but that doesn't mean they will. So you should definitely ask and write it down if they give it to you. They might not. And then you should write down that they did not give you that information when you asked for it.
I think you may have already answered this, but I just want to make sure. Can staff direct people to an emergency exit to avoid interaction with law enforcement?
If someone asks for an emergency, where the emergency exit is, and you just direct them to that and have no idea why they may be asking that, that's fine. But again, if you are deliberately trying to help someone escape from ICE, then that could subject you to criminal penalties. So my recommendation would be don't do that if you know that's what the purpose is.
If ICE officials want to seize documents, records, can the library substitute copies, or alternatively, can the library make copies to keep?
They can make copies, but again, that's going to be at the sort of sufferance of the law enforcement authorities. They can just take the things, which is a good reason, to have backups of things or electronic records. But yeah, they can just take the things without giving you a chance to copy it.
Someone is asking, in children's department where adults with a child are only allowed, and to protect the kid's safety, especially with weapons, can we deny access?
Yeah, so again, you want to be clear, you're not consenting, that this is an area where only children or adults with children are allowed. And since they don't have a child, they're not allowed. They may see it differently. But again, you want to always make clear, this is not an area where you're allowed, and I do not consent to your being there.
Okay, this is going to be the final question because I don't want to keep you here all day, Rebecca. Let's see. So it says, so documentation checklist would be a tool for staff that are authorized to give consent to ICE, right? This is not something we would want to provide to staff that do not have the authority.
Well, I would, so my suggestion is if you have like, say, a binder that's labeled, you know, plan for ICE or whatever, at the beginning of it, you have who is authorized to do what, but a person, whether they're authorized or not, can check off boxes to the extent that they know the answers to them. And they can, and obviously they can write down a narrative. So I wouldn't want to say, I wouldn't want to say, no, they shouldn't have access to it. But what should be clear on the face of it is who is authorized to do what. And should be reinforced, obviously, verbally with staff.
Okay, and that wraps it up because I don't want to keep Rebecca here all day. Thank you so much, Rebecca, for taking time again to share these resources and all of this valuable information with the Illinois library community. We appreciate everything you're doing at the ACLU. So thank you so much for sharing your information with us today. We want to thank everyone for joining us today. And we hope everyone stay safe, warm, and have a nice weekend. Thank you all for your help, or thank you all for attending. Thank you. Thank you again, Rebecca.
Thank you, and I hope you never need this information.
Thanks. Bye-bye, everyone.